Good day, everyone. This is Atty Lou from San Francisco, California, to give you an update on the suspension of U.S. visas. In April, Trump suspended immigrant visas with certain exceptions for 60 days. While it was temporary, it did not serve any valid purpose except to cause delay in reuniting families. On its 60th day, specifically on June 22, 2020, Trump suspended entry of foreign nationals on certain employment-based non-immigrant visas into the United States. This proclamation also extends, effective immediately, Presidential Proclamation 10014, which is the April proclamation suspending the entry of certain immigrants into the United States. What is the difference between this April proclamation and this June's proclamation? Let's discuss first about the similarities. Both proclamations suspend legal immigration. Second, both proclamations apply only to those who are outside the United States and do not have visas issued yet at the time of the proclamation. And third, both proclamations exempt those who are green card holders outside the United States. Now for the differences, the April proclamation bans issuance of immigrant visas with certain exceptions. It did not include non-immigrant or temporary visa holders, whereas now in the June proclamation, it bans both immigrant and temporary visa holders. Therefore, the second June proclamation is an extended version of the April proclamation. What is the effect of the June proclamation on legal immigrants? The June proclamation extends April 2020 proclamation, which suspended the entry of certain immigrants into the United States until December 31, 2020. It also expanded the ban on certain visa applicants, mostly employment-based non-immigrant visas. This June proclamation suspends or bans H-1B visas, H-2B, the J-1 visa to the extent the foreign national is participating as an intern, trainee, teacher, camp counselor, or au pair, or summer work travel program, and any foreign national accompanying or following to join them. It also bans L-1 visas. Significant number of Filipino visa applicants and businesses under the above-mentioned categories will be adversely impacted by this suspension. What about those with approved petitions? How are they affected by this proclamation? With the exception of spouses and minor children of U.S. citizens, preference category petitions that are approved and with priority dates that are current will have to wait until the suspension ends in December 31, 2020. However, it is important to note that the Department of State, through the National Visa Center, is still processing these petitions, and we encourage beneficiaries of these visas to continue and pursue their visa applications. Who are not affected from the suspension of immigration? Among others, these are the categories of individuals who are not affected by the proclamation. Those present in the United States and are adjusting status. So those who have visas that are approved and priority that are current and are in the United States will not be affected by this suspension proclamation. Second, those not affected are green card holders or immigrant visa holders at the time of the proclamation. If an individual is already in possession of an immigrant visa or a green card before the proclamation, they can still travel to the United States. Are all non-immigrant visas banned or suspended from being issued? What about fiancé and visitors visa holders? Are they still allowed to travel to the United States? It does not ban other visas such as visitors visas, fiancé visas, student visas, and investors visas, among others. So as soon as the U.S. Embassy opens for consular services, applicants for the other types of visas that are not included in the proclamation may still pursue their application. Also, those who are not enumerated in the proclamation may still use their validly issued visas. So what other provisions are of importance to our viewers? This proclamation is temporary in nature but has serious impact on thousands of businesses and on immigrant families. The proclamation suspends issuance of family immigrant visas, resulting in further delays. This proclamation came at a time when U.S. citizens and immigrants need their families to be here with them during this pandemic crisis, especially for support for those who are working and taking care of their children. To ban parents of U.S. citizens from immigrating to the U.S. and be with their families is the most cruel provision, as it deprives them of their ability to bond during this critical time. But note that there is this general provision on exemption based on national interest. One of those enumerated are children who are aging out or turning 21 years old. They will be exempt from the ban. So it is important to take advantage of this national interest exemption when applying for the visas. Thank you very much, and until next time, stay safe and well. This is Atty Lou for Pusong Pinoy sa Amerika.